Claudia, it's truly a pleasure having you with us today, and thank you so much for having us at your office. I'm very excited.
Thank you so much for being here, and thank you for this interview.
Thank you. Let's dive in. At first, we'd like to talk about your role here in the ICC, because becoming the first woman to lead the ICC International Court of Arbitration is a monumental achievement. So, how was your journey leading to this role?
So before becoming president of the ICC Court in July 2021, I had worked in large law firms for more than 25 years. I was focused on representing clients in complex international commercial arbitration as well as investment treaty arbitration. And I also had a long history of connection and involvement with the ICC Court. I was even the chair of the Young Arbitration Forum for the ICC many years ago when I was still a young lawyer and when it was still only in the United States before it had become global. I had served on task forces on the ICC Commission on Arbitration and also as an ICC court member and vice president of the court.
Oh, and during all of these fantastic roles, did you ever see yourself like looking ahead, being in this current role?
I think right now this is a job of a lifetime, and I really feel so honored and privileged to have this opportunity.
You've been the president, just you mentioned, of the ICC Court since July. What are the initiatives and like specific directions that you've introduced to the court, and how do you hope that it will leave an impact?
Yeah. Over the almost 4 years, we've really been focused most significantly on ensuring that every aspect of ICC arbitration has what we call a client mindset, that from the moment a case is filed until an award is issued, we are always thinking about the needs of the parties. Of course, there are many stakeholders in an arbitration, including outside counsel, the arbitrators, of course, and others. But if we're really focused on the needs of the parties, I am confident they will have a better engagement with the arbitration process.
And since you usually emphasize on client mindset, how do you see this working, or how are you introducing it?
Yeah, there's often a disconnect between what parties say they want in an arbitration and then what the arbitration actually turns out to be. And I have a view that if the in-house counsel can be more engaged in the arbitration process, of course, not to the exclusion of their outside counsel, but working hand in glove, the arbitration itself will better meet their needs. So, for example, we strongly encourage in-house counsel to participate in the case management conferences when the procedural timetable is being set. We also ask in-house counsel if they wish to be copied on all communications so that they get the information in real time. They might say, no, my inbox is too full, but if they actually want to get this information, we want to make sure they have it.
So from what you're saying is that you find that the impact of in-house counsels on arbitration is actually a positive thing, because some people find it that their role is more of a corporate and they shouldn't be involved. So,
I mean, the in-house counsel are the actual, if the party has an in-house counsel, the in-house counsel are making decisions. They are engaging with the business teams. They are having to make assessment of risk every day, as the role of in-house counsel for companies around the world has really changed. And so we want to make sure that as we're thinking about the parties in an arbitration, we reflect the role that they have.
Now, we've been seeing mediation becoming a lot more popular than the past years. How do you see this impacting arbitration process?
What we know is that when a company has a dispute, they want a resolution. And so what we want to do is ensure that the parties have all of the tools in the toolbox to try to reach a resolution of that dispute. That may be through mediation, it may be through arbitration, or it may be through other means. Traditionally, we have thought of mediation and ADR as steps before an arbitration. But what we want to do is encourage parties to be thinking about all of those tools, including mediation, even after an arbitration has begun, to see if they can reach a resolution.
Do you see mediation ever somewhat replacing arbitration, or do they usually go hand in hand?
If the parties can reach an amicable solution, that is obviously a wonderful outcome, because it can be a win-win for both sides. There are definitely cases, as we know, that parties cannot reach that resolution themselves, and they need a final and binding decision by an arbitral tribunal. So it's not necessarily that there's going to be mediation and no arbitration. It's that we just want to make sure that the parties know and have at their disposal all of the means by which they can try to reach a resolution.
And how do you balance the long-standing tradition of international arbitration with the need to innovate and adapt?
Yeah. I mean, the ICC court was founded over 100 years ago. So one could think that we would be resting on our laurels or just steeped in tradition. But I would say our tradition is actually a history of innovation, that we have constantly evolved to meet the evolving needs of the parties. And so I would say innovation is in our DNA. And as in particular, technology is changing so rapidly, expectations of the parties are evolving. We have to innovate and change to meet their needs.
And do you use AI currently in the proceedings, or do you plan on using them?
So right now, we know that counsel all over the world are experimenting with new and cutting edge technologies, including AI. From our perspective, there are many cautions we have to take into account at this time. Most significantly, confidentiality of proceedings. We also know that many of the tools that are available have hallucinations and other issues. So what we want to do is position ourselves to assess the tools and consider what's going to be the best way, whether that's going to be in the future AI-assisted dispute resolution process, or at some point in the future, whether parties will accept a decision that's data-driven is yet to be seen.
And since confidentiality and the party, it's very essential that there's like some sort of integrity within the process. So how do you ensure that ethics and integrity remain at the forefront of every arbitration process?
Yeah. The trust that parties have in ICC arbitration is paramount. It is why ICC arbitration is recognized, the ICC court is recognized as the world's most preferred arbitral institution. It is why parties literally all over the world trust ICC, whether they're private businesses or states and state-owned enterprises. So in this context, neutrality of the ICC court is top of mind in everything we do, and ensuring that the arbitration process is also one in which parties trust that the arbitrators are independent and impartial.
And reflecting on your incredible and very extensive career, are there any specific cases or experiences that really stand out to you until this day?
Well, certainly for me, the kind of turning point in my career was back in 2001. I was working in Phoenix, Arizona, and the firm I was working for at the time got hired to represent the Czech Republic in what was then one of the largest, if not the largest, investment treaty arbitration case. And I got asked to go to Prague on 5 days notice, originally for about a month, and I stayed for 3 years. And that was really the transformation for me of a practice that was still primarily commercial litigation with a little arbitration to then a full-time arbitration practice.
Wow. And what about your personal experiences? Are there any like personal experiences that actually influence or help in your role today?
I think my experience representing clients in large law firms is what I take into this role. Thinking about when we are representing clients, that we always need to understand the client's strategy. We always needed to understand what is the client's objective and make sure that we were meeting and exceeding client expectations in order to win work and also keep those clients. And that kind of client mindset, focus on the needs of our clients, is what I bring into this role.
And we can all see that you have a very demanding job and a demanding career. So how do you create the balance between your job and personal life?
This job involves so much travel. I feel like I have perpetual jet lag. But I want to be connecting with the arbitration and business community all over the world. There's so much value to face-to-face communications. So I have to find the time to recharge. Sometimes that involves watching some really trashy TV.
We all do that. We're all guilty of it.
But then somehow I feel energized and very excited every day. I really wake up every morning thinking about how can I better communicate the value proposition of ICC arbitration, and how can I really better connect with the community.
And to wrap our conversation, what advice would you give to the younger generation who are interested in arbitration?
Certainly, my advice is to get involved in the ICC global community. If you are a young lawyer, we have the YAF, which is the Young Arbitration and ADR Forum. We have events taking place all over the world. They are free. If you have ideas about programs, you can absolutely connect with the YAF representatives and express your ideas and get more involved.
Well, thank you so much, Claudia. It was really a pleasure, and I really enjoyed this interview, and hopefully we'll see you again and have another interview in the near future.
Thank you so much.
Thank you.